Welcome everyone to today's webinar. I am Ayla Ellison with Becker's Hospital Review. We will begin today's webinar with a presentation and we'll have time at the end of the hour for a question and answer session. You can submit any questions you have throughout the webinar by typing them into your control panel in the space labeled Enter a Question for Staff and clicking Send. We are looking forward to hearing your questions. Additionally, in about a week following the webinar, we will be sending you a copy of the presentation to the email you used to register. At this time, it is now my pleasure to start today's webinar by introducing our presenter, Richa Singh. During her 6 years at CollectRx, since joining in 2010, Ms. Singh has served in a variety of positions at CollectRx. Currently, Ms. Singh serves as CollectRx's Executive Vice President. Ms. Singh's responsibilities include developing and implementing corporate-wide sales and marketing reporting and systems, overseeing the marketing and account management staff and functions, and serving as the lead relationship manager with the firm's largest clients. During her tenure at CollectRx, she has been instrumental in the firm growing its client base to more than 1,300 providers nationwide. Ms. Singh holds a bachelor's degree in computer science from the University of Maryland. Richa, I'll now turn the floor over to you.
All right, thank you so much. Hi, everyone. I'm Richa Singh, Executive Vice President of CollectRx, filling in for John Bardis today. I appreciate you taking the time to be here today, and during the presentation, we'll be talking about what we at CollectRx are seeing with respect to various legal, statutory, and market aspects of the out-of-network landscape, along with some tips on how to improve your reimbursements and thoughts about the future of out-of-network. More specifically, I'll be talking about some of the key takeaways from recent court cases regarding surgery center billing practices, the latest state to pass a law with respect to the so-called Unwelcome Surprise issue, which is California, an update on narrow networks, some of the tactics and strategies used by payers with respect to out-of-network reimbursements that they'd prefer that you forget, and finally, third-party rental agreements, a cost containment initiative that the payers are using more and more to reduce reimbursements. Now, it's a topic that we've covered before, but it's back due to popular demand. Now, to be clear, we are not offering legal advice. If you have any legal matters or issues you need resolved, we encourage you to seek legal advice from an attorney. Rather, our objective when you leave here today is that you have a better understanding of some of the issues affecting out-of-network reimbursements and how you might take better advantage of the out-of-network opportunity. All right, so before diving into these topics, let me provide a quick summary of our experience in out-of-network reimbursements so you understand why we're in a position to address these issues. Now, despite our name, CollectRx is not a collections agency, we are not a billing company, and we have nothing to do with the pharmaceutical industry. But simply put, what we do here at CollectRx is we help providers get higher reimbursements on out-of-network bills. So we don't do this as consultants, but we do this more as experts in negotiating higher reimbursements on out-of-network bills. CollectRx is the only company in the country that's focused solely on helping providers get higher reimbursements on out-of-network bills. We work with more than 1,300 customers nationwide and process more than $1 billion in out-of-network claims each year. We work with a variety of provider types, including hospitals, surgery centers, labs, and physicians. To get the results that we get, we rely on CRIXIS, which stands for the CollectRx Information Systems. This is a proprietary data and analytics tool we've developed to support us as we go toe-to-toe with payers. CRIXIS helps analyze insurance policies, it provides comparable data, and it also allows us to track the tendencies and trends of the people on the insurance company side. In addition to CRIXIS, we rely on our expertise. And we've built a unique team of out-of-network experts who used to work for the insurance companies and their vendors. Now, this puts us in a unique position to understand the soft spots in the payer's position and get higher payments on out-of-network bills for our customers. So now I'd like to discuss some of the takeaways on recent court cases with respect to surgery centers' billing practices. The subject of billing practices is a hot topic in the out-of-network space as we're seeing more litigation resolved between insurers and providers. While the case law is still evolving and both sides have realized wins and losses, there are some lessons to be learned from these decisions and the key factors that courts are looking in or at in evaluating these cases. So these issues are, is there an assignment of benefits from the patient or plan beneficiary? Now, this is critical as courts have determined that an out-of-network provider only has standing to pursue a claim for payment under ERISA where the provider has an assignment from a plan beneficiary. Next, does the assignment clearly identify which rights are being transferred? Courts have refused to allow providers to pursue claims that are not specifically referenced in the assignment. So, for example, one court found that the mere assignment of the right to payment did not authorize the provider to bring a claim for breach of fiduciary duty. Has the provider exhausted its appeals? Now, when a claim has been assigned to the provider, it's crucial that the provider diligently pursue appeals to the payer on any underpaid claims, so meaning that you've exhausted administrative remedies, as courts have often denied recovery on claims where the provider did not exhaust the internal appeal rights prior to bringing suit. Now, some other issues are the provider's charges consistent with what other similarly situated providers are charging? At what level is the provider billing the patient? Is the provider basing the patient's responsibility calculation on the same rates it is charging to the insurer or at reduced rates? How much of these billing practices have been disclosed to the insurer? Providers will need to monitor these cases to further discern the tendencies and trends of what's happening here. Okay, so now let's switch gears and we'll talk about what's known as the unwelcome surprise. And basically the purpose of the unwelcome surprise laws is to protect patients from large medical bills where the patient could not choose or thought they did choose an in-network provider. So in other words, the idea is to protect patients from these bills where it's not their fault that they were charged at out-of-network levels. So the unwelcome surprise, it arises in two distinct but related situations. Now, the first is when the patient receives emergency services where the provider and facility are out of network. In this scenario, the patient literally had no choice of provider. The second situation is a little bit more subtle. Now, this occurs when a patient receives a bill for services rendered by an out-of-network provider that the patient did not knowingly select. All right, so the California Unwelcome Surprise Law, it applies to bills for covered services from a contracting health facility at which, or the result of which, the enrollee receives services by a non-contracting individual health professional. For example, a surgeon performs surgery on a patient at an in-network facility, but the anesthesia is provided by an out-of-network provider. So in this instance, the patient would be responsible to pay at the in-network rate. Now, the law does not apply, however, in a number of instances, including the following. So the law does not seem to apply if the patient received treatment at an out-of-network facility. Remember, the language we just reviewed, the law applies to bills for covered services from a contracting health facility. So if the facility is out of network, this language is not met. And remember, the purpose of the law is to prevent patients from being surprised when they receive an out-of-network bill after going to an in-network facility. So in that situation, the patient would expect the other providers to be in-network. However, once a person goes to a facility outside of their network, there is no expectation that they should be billed at in-network rates, and so they should not be surprised when they are billed at full out-of-network rates. In addition, it does not apply to self-insured plans covered by ERISA, patients who have consented in writing and in advance, plans issued prior to July 1st, 2017, the uninsured, and emergency care, which is handled separately in California. So as you can see, these are a number of very important exceptions. Now, there are a couple of other notable aspects of the California Unwelcome Surprise Law. And for instance, it contains a detailed dispute resolution process to address payer-provider disputes. So for providers to use the process, it's necessary that they exhaust internal appeals first. More unusual is the provision specifying reimbursement rates. The law provides that the reimbursement rate should be the greater of the average contracted rate in the same geographic region, or 125% of Medicare. Interestingly, the law requires payers to disclose various types of data related to what the average contract rate is. Now, on a final side note, several other states are considering unwelcome surprise legislation, including Rhode Island, Georgia, and New Jersey. So if you'll recall, we discussed narrow networks in great detail at the webinar 6 months ago. And since that time, the Penn Leonard Davis of Health Economics issued a study entitled Trends in Physician Networks in the Marketplace in 2016. It had some interesting findings with respect to the distribution and growth of narrow networks. So what is a narrow network? A narrow network is an insurance plan limiting the number of participating providers in exchange for a reduced premium. And payers are increasingly offering narrow network policies, particularly within ACA exchanges. The reason? It's because narrowing the network allows the payer to offer lower premiums, as only less expensive providers are allowed into that network. So in other words, there are fewer providers in narrow networks. And we're not just seeing smaller providers excluded from narrow networks, rather we're seeing major providers as well in major markets being kept out of these networks. And the one big downside stemming from narrow networks for patients is choice or lack thereof. So narrow networks by definition result in there being fewer in-network providers. As such, narrow networks lead to more out-of-network providers. It's therefore becoming increasingly important for these providers to understand how to handle out-of-network billing. So the Penn study found that states have a wide range of differences in the prevalence of narrow networks. So as you can see here on this slide, plans in some states offer mostly narrow networks, such as Kentucky and Virginia. In other states, narrow networks are quite rare or non-existent. You can see that in the green and non-colored areas of the chart at the bottom. So the Penn study also examined narrow networks as they cut across specialty groups. And the study notes the most common specialty groups among practicing physicians are primary care at 29%, hospital-based at 17%, and surgery-related at 16%. The study found a striking similarity in network sizes across specialty groups, with the exception of hospital-based specialties like radiology, anesthesiology, emergency medicine, and pathology. Network size for primary care physicians is very similar to overall network size, with 31% having extra small or small networks. For pediatrics, only 23% of plans have small or extra small networks. With the notable exception of psychiatrists, specialist groups are less likely to be in narrow networks compared to primary care groups. The one outlier, as noted by the authors, are hospital-based specialty groups where 72% of plans have either extra small or small networks. This is significant given that this is the group of physicians, hospital-based specialty groups, that are most likely to lead to a surprise out-of-network bill. Okay, so that leads into the broader view of the interplay between the unwelcome surprise and narrow networks. Perhaps the biggest issue is the intractable conflict between narrow networks and unwelcome surprise laws. Now, if you're a proponent of narrow networks, what happens? With narrow networks, more providers are out of network and therefore more patients suffering when they receive the unwelcome surprise. If you're a proponent of protecting patients from the unwelcome surprise, what happens? You'll need more in-network providers so patients aren't surprised when treated by an out-of-network provider. but that means more narrow networks. So it's difficult to have it both ways, and it will be interesting to watch the interplay between these areas. All right, so let's switch gears and talk about the impact of the election on out-of-network. And the big talk, of course, is what's going to happen to the Affordable Care Act. Now, this seems to change on a daily basis. Just 2 nights ago, I was reading a story that legislation was being considered where the key cornerstone was allowing individual states to have the ability to decide whether to participate in the ACA. Obviously a moving target, but let's try to sift through it to see what it means for out-of-network. So we've all heard the phrase repeal and replace with respect to the ACA, and it certainly appears that the Republican-controlled Congress and White House is serious about this initiative. But the question is, what does that really mean? So what will be repealed? What, if anything, will survive? And what will the replacement be? So what does the ACA look like today? Well, for one thing, there are many more people with insurance than were insured previously. Over 20 million people are insured under the ACA, and most of those people did not previously carry insurance. So what are their characteristics? Typically a relatively sick portion of the population that tends to be lower income and stands largely outside traditional employer-based commercial insurance. Now, with respect to out-of-network and the ACA, while the policies vary and all plans aren't necessarily friendly towards out-of-network care, nevertheless, a portion of those that signed up have out-of-network benefits. And given the fact that some of the 20 million plus people signing up weren't previously insured, by simple math, this increased the number of insured seeking out-of-network care. So as a final note on an issue not receiving enough attention, we have seen a number of payers pulling out of the exchanges. So in August, for example, Aetna, they announced it was pulling out of most ACA markets. It turns out that the cost associated with the pre-existing conditions mandate made the economics not work for many payers. So even the Republican-led Congress and White House did nothing. In our view, there would be troubling times ahead for the ACA. So what might we see with the replacement legislation? These are the areas that are receiving the most attention. First off, payers cannot exclude for pre-existing conditions. A key part of the ACA, it seems like the government will have no choice but to keep it. In revising and replacing the law, there's an opportunity for the government to dictate a different social policy, such as excluding coverage for birth control. Allow families to let their children stay on their parents' insurance through age 26, make participation voluntary, not mandatory, more market-driven with a national marketplace, and continue to encourage narrow networks. So with respect to out-of-network, it's difficult to see how any of this is negative. With the emphasis on narrow networks, the impact of which we discussed earlier, along with driving patients to a more commercial insurance, we're more likely to see a positive impact on out-of-network. So now let's turn to some of the issues we see on a daily basis in the market as we go up against the payers every day on behalf of our customers. So you need to remember that the payers and the vendors that work for the payers helping them, they reduce out-of-network reimbursements and are continually looking for ways to underpay claims. They engage in cost containment initiatives like getting you to enter into third-party rental networks, which I'll discuss next. They'll also utilize narrow networks, they'll send payments to the patient, and sometimes they'll even threaten providers. Now, this is all aimed at reducing payments to providers. So here are a few tips that you can use to get the most out of those reimbursements. Avoid the portal. Some vendors use a portal to send proposed single case agreements to providers, and providers use it because it's easy and it's more efficient. But what they don't realize is that the portals are set up so you can't negotiate the case. In fact, some vendors won't even take calls regarding the cases that were transmitted using the portal. Also, you won't know things like non-covered amounts or special policy types. So if you take nothing else from today, turn off that portal. Tracking third-party contracts. So vendors sell contracts to providers that promise great rates. The catch, though, and what they don't want you to know, is they're applying various cuts such as usual and customary and multiple procedure reductions. So many times, your final rate is a fraction of what you thought it would be. That is, if you checked. Many providers don't even track their payments to see whether they're being paid correctly. And it's hard to blame them. I mean, these EOBs, they're written in such a way that makes them difficult to read. And it's important that you check your EOBs to make sure you're paid correctly. Retro authorization. Another thing the payers don't want you to know is that sometimes, not all the time, but sometimes you can get authorization after the fact. So don't give up if your claim is denied for that reason. Just try to get retro authorization. The persistence game. So finally, that's what we call, or there is what we call the persistence game. Who's going to win the battle of the wills? The payers and vendors put up obstacles to success, banking literally that you will get up and walk away. Their goal, their sole aim, is to get you to throw in the towel. And they know you're busy and don't have the time to continue the fight. And remember, the vendors are paid on a commission basis, so when you give up, they win. Ultimately, to succeed, you must have the persistence to continue fighting for the reimbursements you deserve. Okay, so let's switch gears and talk about a cost containment tactic being increasingly used by payers to reduce out-of-network reimbursements, the third-party rental network agreements, and so-called silent PPOs. And as well, we will discuss continuous discount agreements. This is a topic that we get asked about all the time. Every day, we're asked by providers to review contracts they're considering entering or contracts they're considering canceling. So even though we've covered it before, we're going to talk about it again today. So what is a third-party rental network agreement? Third-party rental network agreements are agreements signed not with an individual payer, but with a third party that contracts with a lot of payers. Now think of the third parties like middlemen of sorts. So they're bringing together payers and providers to participate in contracts that often are not favorable from a provider perspective for a number of reasons. Moreover, they are often offered to other payers and networks that the provider doesn't even know about, this so-called silent PPO. Now they sound easy. With one contract, you essentially have a contract with all of the payers that are signed up on their network on the other end. Most providers, however, as we'll talk about in a bit, don't understand how detrimental they can be. So it's important to understand who is the customer with these agreements. And to be clear, it is not the patient, it is not the provider. It is the insurance company. I mean, go check out their website, you'll see it right there. The reason this is important is that they are not there to serve you, but to serve the insurance companies. And they do so as a cost containment initiative for the payers. So think about it. If they're helping insurance companies save money, who's losing that money? So while these agreements may sound attractive because they're easy to implement, these relationships oftentimes have unintended consequences and should be closely scrutinized. Now let's review some of the specific issues that often arise in these agreements. How do they treat patient steerage? To be clear, there is typically no patient steerage from rental agreements. So in the traditional managed care contract situation, you're essentially agreeing to a volume discount in exchange for the insurance company steering patients to you. In contrast with rental network agreements, you're accepting a discount but typically are not seeing any additional patients. Do providers know they've entered such agreements? Not only do providers have no idea of the breadth of these agreements, many providers don't even know they've entered into them. They were signed years ago by staff no longer at the facility, and the provider doesn't even know it. Are the payers required to use a contract? No. To begin with, payers have multiple agreements and will choose the one with the best rate. Also, there may be types of claims, such as those with limited benefit policies, that they don't use the agreement to price. So in other words, if the reimbursement level would be lower than the contracted rate, then they won't take the contract. but if the reimbursement level would be higher than the contract rate, then they will use that contract. So as an example, suppose the contract rate is 60% and the vendor is pricing a claim with a Medicare-based pricing at 125% of Medicare. Do you think the vendor is going to use the contract or the Medicare-based pricing? They'll choose the latter, of course, and in essence, the contractor rate is really just a cap on their out-of-network reimbursements. All of this benefits the payer, not you. Are the reimbursement levels adequate? As we've discussed, out-of-network reimbursements industry-wide are generally higher and sometimes much higher than contracted reimbursements. So how do the reimbursement levels compare to being out-of-network? And that brings up a related question. Are the reimbursement levels based on a percentage of billed charges or allowed charges? So sometimes providers don't realize that the reimbursement levels are based on a percentage of the allowed charges, not the billed charges. This means that payers take a cut to arrive at the allowed amount, then they apply the discount to that lowered amount. So let's say you have a case with $10,000 or with $10,000 in billed charges, and the agreement says they're reimbursing at 70% of allowed charges. The payer then determines on that $10,000 bill what the allowed charges are, and in this example, assume the allowed charges are 60% of billed or $6,000. Then the payer applies the discounted rate from the contract of 70%. Of course, 70% of $6,000 is $4,200. So you wouldn't be getting the $7,000 you may have been expecting for this case. You're only getting $4,200. Are you allowed to terminate at will? Now, typically these contracts are for one-year terms and are subject to an evergreen clause, meaning they'll automatically renew on a yearly basis unless terminated by either party. The catch here is the notice period to terminate. Sometimes the notice period is 180 days, meaning that you have to give 6 months notice just to terminate. And that notice must be at least 180 days prior to the anniversary date of the contractual period. So follow along on this slide, and let's suppose that you entered an agreement on July 1st, 2015, and you decide in April 1st, 2016 that you want to cancel it. Since you're less than 180 days from the anniversary date of July 1st, 2016, you couldn't cancel it until July 1st, 2017. So in other words, on the following anniversary date. Now this is extremely onerous termination process. However, keep in mind that there can be shorter termination periods for certain networks as specified in the contract. All right, so additional items to consider. Are payers applying in-network discounts with out-of-network benefits? The answer is yes. Most providers, however, just assume that in-network benefit levels are being applied. Does the agreement provide for claim edits? A lot of the times they don't. Is there a reference to an administrative handbook? Oftentimes these agreements explicitly incorporate the terms of the handbook into the contract. So things like multiple procedure reductions might not be addressed in the main contract, but is addressed in the handbook and you don't even know it. I've even heard of reimbursement rates being changed using the handbook, and how many of you out there review it when changes are made? The bottom line here is if you're in one of these agreements and you're answering no to many of the questions above, you should seriously consider whether to cancel the agreement. Similarly, if you're considering entering into one of these agreements and you're answering no to these questions, be very careful in making the decision to enter into these agreements. As you can see, in a lot of instances, these agreements hurt, not help your reimbursement. Now, let me talk about a cousin of the third-party rental network, the continuous discount agreement. This is another cost containment tactic used by the vendors for the insurance companies to lock you into reimbursement levels that are quite low. The way it works is that when signing a single case rate agreement on a negotiated case, there's a checkbox with language stating something to the effect of, by checking here, I agree to accept this level of reimbursement on claims in the future. Many providers don't even realize they've entered into these agreements because oftentimes they were checked off by a staff member or even a temp years ago, and those personnel are no longer at the facility. And of course, because EOBs are difficult to read, many providers don't even realize these EOBs are even referencing these agreements. These suffer from many of the same issues as third-party rental networks. For example, you're certainly not getting any steerage of patients from continuous discounts agreements. Excuse me. The good news is that they're relatively easy to cancel excuse me, with a modest notice period. At a minimum, we would encourage every provider to look at these agreements closely and make a determination as to whether to cancel them or not. So let me wrap up with a few words about the future of out-of-network. A question I'm asked about quite often. What is the future of out-of-network? Now, I think the reason I'm asked this question so often is that there's a critical overarching point to remember. Out-of-network reimbursements are higher and frequently much higher than in-network reimbursements. Not always and not in every geography, not with every payer, but generally speaking, out-of-network reimbursements are higher. The key is making sure you're good at it so you're in a position to maximize the opportunity. When we are asked about the future viability of out-of-network, as you might guess, we are pretty positive. Now, it's a $60 billion market, and there are favorable winds blowing in that direction. But most importantly, people want to have the choice of provider and will pay for it. While insurance companies want to minimize what they pay providers, they are more than happy to accept the premiums that come along with out-of-network benefits. So finally, let's face it, as providers survey the landscape today, candidly, there aren't many opportunities to improve your reimbursement rates because in-network contract rates, they are what they are, and they're limited, if any, opportunity to increase the rates. And with respect to Medicare and Medicaid reimbursement rates, there is no opportunity to change those rates. But leveraging out-of-network reimbursements represents a last great opportunity for many providers to bring more dollars in the door to improve the bottom line. So in sum, I hope you have a better idea of what's happening today with respect to out-of-network. Also, remember that when done right, proper out-of-network reimbursement management is one of the only ways providers can improve financial performance. So again, thank you for your time, and I hope you found the session useful. I can take questions now.
Thank you, Risha, for that fantastic presentation. We will now begin today's question and answer session. And please submit any questions you have by typing them into your control panel in the space labeled Enter a Question for Staff and clicking Send. We will try to get through as many questions as we have time for. So we'll go ahead and start on the questions that we already have. And Richard, the first question is, I have claims involving MRC2. What is that?
Okay, so MRC2s, it refers to something we call limited benefit policies, and they're offered by Cigna. And they're similar to United Healthcare's MNRP policies, if you're familiar with them. And basically what these plans do is they tie reimbursement rates to a percentage of Medicare. Now, the good news with this is that the majority of your cases are still based off of usual and customary, but with these certain Medicare-based plans, you know, if you know what you're doing, you can get higher reimbursements on these cases at least some of the time.
Great, thank you. And moving on to the next question, it is, what are the ID card requirements in terms of a logo identified for the typical third-party network?
That's a good question. Okay, so the logos on these ID cards, they're completely irrelevant in these agreements. So that's why sometimes you'll hear them referred to as silent PPOs. Now, you know, sometimes you might see that a provider comes in and they have the network logo on their card, but the payer doesn't recognize that logo or is not obligated, basically, to utilize that network. Now, a way that these networks can also make money is they'll, you know, lease out their network to other payers. So, you know, smaller TPAs or worker comp carriers, for instance. And what they'll do is they'll basically just charge them a single usage fee, and all they require is that the payer will notate on their EOB that they're basically using that network.
Perfect. Thank you for clarifying that. And the next question is about narrow networks, and it is, what is the best way that I can identify if I am included in a narrow network?
You know, the specific provisions are usually within a contract, but given the age of most contracts, it'll probably be in some sort of an addendum to the contract. So I think it would be best to probably check with your legal department or with the rep at your payer to get your status.
Perfect. Thank you. And there's still a lot of questions coming in, so we'll go ahead and move on to the next one, which is, I have cases where I'm out of network with the same insurance company with the same procedure, and yet I'm reimbursed at very different amounts. How can that be?
Okay. Yeah, so ultimately it's not the insurance company that completely drives what usual and customary is for any given bill. The employer groups are really the ones who control that. And not only are they controlling what the out-of-network benefits are, but they're also controlling or determining the methodology that they use to come up with that usual and customary pricing. And another thing is, I mean, it's funny because you'll even see that there can be differences even within the same group. So that's why I keep saying, you know, it's really important to be vigilant in reviewing your EOBs.
Thank you. And the next question is, you mentioned a bill in Congress that would give states the choice to keep Obamacare. Can you tell me more about that?
Yeah, sure, what I can remember. There's a couple days ago, and basically it states 3 options. So one of them is just keeping the ACA. The second one was that, you know, basically it gives states most of the federal funding promised under the ACA. And third was just basically, you know, rejecting any federal assistance altogether. But I wouldn't draw too many conclusions from this yet. It's just really uncertain and still too early to understand what comes from it.
Perfect. Thanks for that clarification. And moving on to the next question, it is, what's the best way to maximize our appeal success on underpaid claims? Okay,
so I'm assuming they're talking about out-of-network claims, but there are definitely, with out-of-network claims, several things that you can do to be successful. You know, you need resources for any out-of-network appeal. I mean, these appeals just don't happen by itself. And your resources, they'll need data to actually make the arguments to win against these payers. A couple of other tips that they'll need to know is, you know, okay, when do I call a payer, or in this instance, should I write a letter to them instead? And then how or when do I escalate the appeal? So again, I said it earlier, but with any of these negotiations, you really need to be persistent. Oh, also, with one tip with in-network appeals, get your rep involved because they can really help you bridge that gap.
Well, thank you. And it looks like we have time for one more question, and we'll go ahead and move on to that. And it is, I receive faxes from companies proposing settlements of cases, and I throw them away. Is that the right thing to do?
No, you should give them to us to negotiate. No, but seriously, I mean, any provider should definitely negotiate these proposals, because if you don't, what happens is the vendor will send it back to the insurance company and they reprice it down to much lower levels. So definitely negotiate these proposals.
Well, thank you for that last piece of advice. And that is all the time that we have for today. And I want to thank Richa for her excellent presentation and to our audience for participating today. Please enjoy the rest of your day, and we look forward to having you join us for future webinars.